I see live from Sarah, so I guess we can start precisely on time. A good day, I guess I should say to everyone, since we are in different zones. And I hope everyone is as excited as I am to attend, to be part of this wonderful event with quite outstanding academics discussing or engaging rather with international human rights law in the aftermath of a global crisis. And aftermath, in my case, I'm putting it already in brackets. I don't know whether we are in the aftermath or not. Now, you saw, of course, the flyer and the issues, the kind of the thread of the issues that we intend to discuss. And we'll basically really do it in a salon and have it in a more relaxed kind of format where we exchange on different things and pick up from what someone says, and then we will really follow from that. Now, we are. Allow me first of all to present who is here before, and then make quite a few remarks, and then I'll open the floor. We have four, as I said, outstanding speakers with from quite different parts of the world and with quite solid CVs as researchers, lecturers, among many other things. First, we have Kjersti Lorne, who is an associate professor in criminology at the University of Oslo. And she has quite a long research experience that is at the intersections of legality or illegality, politics, and expertise across the sectors of international, humanitarian, and human rights law. One of the important work she has authored is Advocates for Humanity, or Advocates of Humanity, rather, Human Rights, NGOs, International Criminal Justice, and in International Criminal Justice. And she has also published quite a lot in across disciplines, international politics, law, sociology, among many other things. She works at the University of Oslo, and I'm sure researchers among you can still check her even more longer CV on the website of the university. Next, we have Lionel, and I'm not following any order at all. We have Lionel Zevonu. And I mean, I'm African, but I will massacre names, and forgive me preemptively for that, please. Who is an associate professor in public law at Université Paris-Nanterre. And his area of research is jurisprudence, law and social sciences, and economic law. And since 2018, he has been appointed for 5 years at the Institut Universitaire de France. And since then, he has been developing research projects on race and racism in France and European law. And he is the author of Race et Droit, Institut francophone pour la justice et la démocratie, one of the latest publications, but also Penser la race en juriste. Third, we have Nicola Palmer, who is a reader in criminal law at the Dixon Poon School of Law at King's College, London. And her work basically is around interpreting the layers of justice. And she's author of Courts in Conflict and interpreting the layers of justice in post-genocide Rwanda, among many other things, but also has been working on especially the intersection between law and immigration law and so forth. Again, like any other speaker, you can check more the longer CVs that do more justice to what I will be presenting here. Finally, last but not least, of course, we have Siba Grovogui, of course, who is a professor of international relations and theory and law at Cornell University. And he has quite a long, of course, experience. I can't do justice in this just few minutes, talking about his long experience and publications from the early publications like Sovereigns and Quasi-Sovereigns and Africans, but also his recent research on the human, if you will, among many other things that we'll be discussing today. Now, few words, if you allow me, before I come back to our distinguished speakers. As a way of opening this talk, and introducing the many different issues that we'll be debating, allow me a little bit to kind of draw inspiration from the African storytelling tradition and take a small walk on memory lane. And that will take me to the time when I studied human rights law in a master program at Raoul Wallenberg Institute in Lund, Sweden. I understand we have another Raoul Wallenberg Institute in Canada, but I'm talking about the Swedish one. That was in 2005-06. And at that time, my professor of international human rights law was Ineta Zimele, who was from Latvia, who later became a judge at the European Court of Human Rights in Strasbourg. And among the literature we had to discuss at the time on topical issues, there was issues of fragmentation of international law, with the figures like Marty Koskeniemi as the main kind of leaders in this current of critical international scholarship. Now, we asked, we were assigned his literature, The Gentle Civilizer of Nations, among many other things, but also his reports for the courts in The Hague. But then, which I found quite interesting. But then I asked the professor if you could invite him, since he was a neighbor, virtually a neighbor, Finnish, Sweden, to come and lecture us on those issues. And the professor was, this is too early for you. I wouldn't want you to have him here because he will turn you into rebels against human rights. And my understanding was that at that time, really, we were being taught into kind of receiving a certain given dogma of human rights, basically to be schooled into becoming believers, if you will, of what Elie Wiesel called, of course, this secular religion of human rights, and become basically, if you will, what the Trailers would call conventional doctrinalist human rights lawyers. Now, afterwards, of course, I had to follow up on that literature. As Sarah just mentioned a few minutes ago, I discovered the more critical scholarship on international law, international human rights law. I read a few things around the Trailers. Among many other things, James Gathuo's International Law and Eurocentricity, and of course, Makawa Mutua's, ideology of human rights, savages and victims and saviors. But also dived into the early scholarship, which did question certain given kind of narratives around the foundation, origin, and essence of human rights, including, for example, the works that informed the establishment of the African human rights system. Now, of course, we know that this debate, all of this to say that these debates, that many of the things also we'll be discussing have been already being debated for quite some while. But of course, they have become quite more important in this era with the pandemic, but also such kind of societal issues being debated today as racism, racial justice, decolonization of knowledge production, among many other things, Black Lives Matter, and so forth. Now, what is important and an honor to me, for me, of course, is that when I was reading those materials as a young scholar, is that I wasn't even much aware of course, this is a critical moment for me, that Gathuo's article that I mentioned was a review article, of course, of two books, among others, the work of Siba on sovereign, quasi-sovereign, and Africans. And it's a pleasure now really to be discussing some of the issues, of course, with more contemporary relevance, issues such as, of course, race, class, power, empire, inequality, marginality, beyond not legalistic lenses, but also to be looking at the intersection between international criminal law, international human rights law, international criminal law, but also other social sciences. With that in mind, I'm still that student, of course, who would love to know and hear more about when we talk about human rights, what are we talking about today? What is human rights? So since we are engaging in human rights in the aftermath of crisis in this debate, what is human rights? Maybe allow me now to turn back to use again the African notion of droit d'aînesse and ask Siba to chip in here. And that's what I assume, I guess. Siba, what would you, if we talk about human rights today or yesterday, what are we talking about? What is the essence of human rights?
Thank you. Yes, human rights is obviously but because we are already in the English language, we should accept it to be a linguistic device, the concept itself, which has a cultural weight. And of course, that cultural weight has to do with some political and social struggles that led society to go to adopt certain institutions that they thought pertain to both to the human, to ennobling human life. And in that sense, human right today, in any context, is almost like a technological device in a very, very real political, social, and cultural contest. I'm sorry. And that is how I understand human rights. Human right has it comes from the idea that we as human, though we are biological entities, that we are also moral entities, and we are spiritual entities. That the human, there are certain things, faculties and capacities that make the human human, that have to be protected so that human life is ennobled. That is actually the core idea of human rights. But even in this simple description I'm giving you, we can already see that when we say human rights in international context, as well as domestic setting, we're actually leaning on ontology, on morality, on the normative and the ethical. And ontologically, of course, there's much room to debate what the human is and what rights are. Morally, there shouldn't be a lot of questions about whether human life ought to be enabled. That's the part where you can say comfortably that every human civilization had ideas of human faculties and capacities that need to be protected. That is not just Western, that's everywhere, right? And the problem from our era, of course, is that as the introduction, we heard in the introduction, there is always a normative weight that we give to human rights. And in that sense, when I was talking about technologies, I was thinking about human rights as a tool of governance in the way that we govern ourselves today, which ought to actually lead us to ask some questions that are of ethical nature. And I want to say that, and I'm not going to be long, and that has to do with the fact that in the 18th century, especially in the context of the American, Cuban, and the American, Haitian, and French Revolution, of course, the idea of constitutionally, the insertion of the language of right and the human and etc. of people and etc. had to do with the fact that we were undergoing crises. And those crises were of society, of economy, of governance, empire, economy, the plantation, etc. And if you look at it that way, obviously, we should at least contemplate the idea that no matter where we are in time, that those questions never disappear. We still today, speaking up to today, of course, today, we are also in a crisis of society, economy, politics, governance, morality, and etc. That's where we are today. Some of it has to do with the shift from the welfare state to, whatever, the rise of neoliberalism and etc. The disintegration of certain social projects after the end of communism. But today, obviously, the state is relinquishing questions of morality and adjudication of the good to private capital and etc., which actually will lead me at some point to the question of drugs and etc. And so what used to be, right? And so the question of human rights was always, from the beginning from the 18th century until 1948, right? The question of human rights was always was not only important in its conception, but it was also important in at the level of adjudication. And in 1948, we were thinking about the state play a big role, international institutions, and et cetera, which meant that questions of justice, the social justice, morality, and et cetera, were not left to particular entities to adjudicate, right? And obviously where we are today is that we seem to have backtracked from that. So what becomes of the state of the human and of rights in economies where labor, people are marginalized, the state no longer has a commitment to effect justice and et cetera, that actually becomes, for me, the context in which we should go back again to the origin to see what human rights were and what they were supposed to do and where we are today, right? Those questions have not disappeared, and we cannot be comfortable in sort of hanging on to a particular conception of right, which is why I take 2 minutes and then I'll shut up. I'll close here. You see, you can think of the 3 evolutions I was mentioning earlier, and just think of particular ideologies with regard to the human and human rights and etc. If you take the American Revolution and you take the first 10th Amendment, obviously what you have there is the origin of what we call liberal conception of political and civil rights, right? If you take the French Revolution, obviously it's the right of the citizen. That was it. Was about citizenship, ownership of institutional governance, and et cetera. Haiti had a far more profound ambition. And that ambition is what we don't capture, and that's actually why I'm writing the books that I'm writing now, because that is actually, so basically the way to think about that is if you think of liberalism, the individual, which was the emphasis of all the rights of the first 10th Amendment, the Bill of Rights, the liberal is human in particular capacities, but liberal conception of human right do not exhaust what it means to be human, not in all its capacities and faculties, right? The citizen is also human, but does not exhaust what it means to be human. In Haiti, they had imagined, because the Haitian was both outside of the social order and was victim of economic practices, right? They had an ambition to think of the human, where the human is outside of the political compact, victim of the economy and the state, shackled by the state, marginalized by society, and etc. And so they had to imagine what it meant to be human from the time we are born to the time we are dead, and what were the most important capacity, what was the important need of the human, and therefore that to be met. And that is why they imagined rights today that a lot of people refer to as socio-cultural or socio-economic. The absurdity of commenting about that is that obviously individual right and citizenship right can only emerge in a particular historical political context, cultural context. So those were actually the ones that were socio-cultural. The ones that were human, that humans must have from the time they are born to the time they are dead, whether they are capable of protecting themselves, or victim of states, of husbands, or economies, and et cetera, et cetera. Those rights are the ones now we absurdly refer to as social culture, but they are not. They are actually the ones, the right to shelter, the right to eat, to be fed, the right to whatever, are actually the ones that humans in any capacity, whether you are in a political order, whether you are on the plantation, no matter what your conditions, those are the ones humans need the most. And those are actually the ones that do not abide social cultural context. So in fact, the normative interpretation of human rights today has reversed that. And we call what we call social, political, and public rights are obviously social cultural. And the ones that are more fundamental are now called social and economic. It's a perversion. It's a perversion. Yes, it might be that what we call human right, what in Haiti and quilombolas in Brazil called human right, are much more difficult to give to the human because our societies, the technology of production, governance, and etc. are far more complicated, and therefore they are difficult to, but the difficulty of attending to something does not negate substantively what that thing is. So yes, it might be difficult to give that to people, but it doesn't mean that they are lesser right. They may still remain the most fundamental right, right? And I do that as an introduction because I don't know where the conversation is going, but I opened that way. Thank you.
Fantastic. quite very challenging. I'm not quite sure whether you have not derailed the rest of the conversation by even more complicating the debate, but that's exactly the essence of the kind of provocative interaction that we would want. I don't know even if I should call it provocative. Now, that brings in then issues really that are, again, I would direct now as the follow-up question to Shesti. I mean, you have worked on issues of both human rights, international criminal justice, but also very importantly, agency, the issue of agency, how agency is articulated in, let's say, projecting, advocating for those rights, whichever those rights are. Now, if you read the emerging literature, the likes of Samuel Moyn and so on, they tend to insist on quite rather more recent, let's say, genealogy of, let's say, certain given articulations of human rights. Now, in your work, how do you see that agency playing an important role, let's say, projecting or reflecting on some of the things that Siba was just raising? Back to you.
Yeah, sure. Thank you very much. It was indeed a lot of food for thought, Siba, that you came with. So I'm happy to join this conversation and honored to be doing so. I think we'll be talking a lot about agency here, global agency in relation to these sort of global structures of power that we'll be returning to a lot, I think, in these two hours to come. But I wanted to sort of connect a little bit with what Siba was talking about, because I very much enjoyed his sort of opening. I mean, your question, Felix, what is human rights is so broad, right? And how to approach that is so difficult in itself. And human rights is that it is so broad. It's both its power, but also its weakness, right? And then Siba talking about how human rights is first and foremost really a rhetorical device, I think I found very, very fruitful, a very good way to think about it, because the way that I've approached it, and I'll come back to agency, is I was interested in human rights as sort of a universal, right? As sort of this rhetorical device of being a global universal, as Siba was talking about, the human, and that's something that we have just simply by being human, by existence. So it is sort of already out there. It presupposes that it's something that we have, and therefore that it is universal. But we know that it is not, right? I mean, if it was a true universal, it wouldn't even need articulating, because it would be so obvious, and it wouldn't need implementation because we would all have it. So it's this friction that I've always been curious about between sort of claiming that it is a universal good, but at the same time, it needs to be implemented, it needs to be articulated, and it needs to be driven forward. And it is this driving forward, and it's this sort of work of implementation that I find that I've looked into, particularly in relation to international criminal justice, or to struggles of moving forward or finding justice in the aftermath of war and international crimes in particular. But before going there, I also want to say another one, because Siba's thoughts were really inspirational. And I think, returning to this work of the universal, it is also very geopolitical, right? And as you said, Felix, now, I mean, the sort of more recent trajectory of human rights may have started, in the post-World War II, and then it kind of exploded after the Cold War. And I see this as sort of, it is intimately connected to geopolitics and power in the international order. And the work of the universal, the work of global universals, are much more easier to implement when there's only one unilateral power in town, the US, for instance. Now, this friction that we're seeing, this resistance towards human rights globally, but also nationally, I think can be attributed to these changes in the geopolitical system of ours, that there's now, I mean, we no longer have sort of one unilateral power. There are multiple powers in the global order, and it makes sort of the work of the universal much more difficult to implement and to speak of, because it doesn't resonate as much with people. So I know I've already spoken a lot, but returning to this agency, I particularly looked then at these human rights NGOs and international criminal justice. And what struck me was, coming to it as sort of a criminologist, human rights have sort of always been a normative bulwark against penal excess or penal power at the national level. Human rights is sort of defense rights nationally, but at the international level, it became victims' rights. And it became quite concerned with punishment and with penal power. So it took on a different sort of characteristic when it compared to sort of the national criminal justice sector. So I came at international criminal justice intrigued by this, because people told me that the International Criminal Court was a court created by the masses, and that these human rights NGOs had created or been at the forefront of sort of the fight against impunity for international crimes and the creation and the campaigning for international criminal tribunals. So my work, and we can connect back to it, but it sort of tried to deconstruct this. So who are the actors? Who is it, like, who do speak for global justice? Who are the advocates of humanity in terms of speaking on behalf of humanity and on behalf of victims internationally? And what I found was that there are quite some serious structural inequalities in who is able to speak for the global, who is able to speak for global justice. And particularly, there is sort of a Western imbalance here, where it's sort of, yes, there's this global civil society that apparently is composed of over 2,500 organizations, but when you do start to deconstruct it, you find that there are really the major players are, you know, the usual Western-based NGOs. And you start to sort of find out that it's that there's a lot of structural inequalities in the materials and sort of in the material foundations and structures of international criminal justice, and particularly human rights advocacy to it. I can speak more about it, but I think I'll head back to you, Felix, and then we can return, because otherwise I'd speak for 2 hours.
Fantastic, Shested. I very much appreciate. And I guess my follow-up question goes to Nikki, of course, since also you have kind of complementary expertise where you work both on human rights related issues, but also with the bridge to criminal law or international criminal law specifically. Now, Nikki, of course, already you have navigated both the context of law in your book on, of course, in conflict, where you look at different layers and spaces where different norms are articulated when dealing with more or less same context. But also then, more recently, of course, you look at also even sometimes the outflows and the way, especially your expertise being on Rwanda, you look at how, for example, immigration laws are, mobilized and in order to deal with certain given kind of issues, border control, among many other things. And I see here both a question around the correlation already that Shesti has explored, the correlation between human rights law and international criminal law. So maybe if you can come a little bit deeper into that. But also very importantly, the issue of power and again still agency when it comes to both navigating both fields, if you will. The question may not be as clear, but I'm sure that you know what I'm talking about, Nikki. Back to you.
Wonderful. Thank you, Felix, and thank you, Siba and Kirsty, for starting this discussion. In fact, all three of you, I think it's as we've sort of noted, I think it's very rich already. So I think that I'm going to pick up on Siba's first point of the sort of that we recognize aspects of humans as needing and warranting protection. And then to kind of tie with Kirsty's comments of then saying, well, one of the ways we've seen this, one of the ways we've seen the institutionalization of human rights has been through penal power. And Kirsty, I think your work's been really important in pushing the criticism of that and raising the question of why at the international level have we seen this what Karen Engel has described as a turn to carceral power, or a turn to penal power, or Matteo Pinto sort of pushed and said, actually, it's really just an acceleration towards penal power. And I think that this sort of, this brings us, I think this is quite illuminating and really warrants us to think about why this has happened and why this has happened at a particular time. Because one of the new projects that I've been working on has been looking at the intersections between what gets classified as transnational criminal law, which generally concerns human trafficking, money laundering, piracy, corruption, and that's being promulgated through suppression treaties at the international level. And then international criminal law, these core crimes of genocide, war crimes, and crimes against humanity. And I recently reviewed Greg Schaffer and Eli Aronson's book on transnational legal orders. And what they did was they brought together the international and transnational criminal law, and particularly empirical studies in these areas, and brought them into one single conversation. And what I saw when I was reading that kind of united conversation was the shared temporal, substantive, and geopolitical dynamics at play that really show, I think, how penal power through public international law has been drawn on as a way of ordering the globe at a very specific time that we could call late modern capitalism, or at least certainly at a time when the movement of goods, people, and capital around the world has accelerated. And so at the same time as people have been moving, money has been moving, and goods have been moving at an increasing rate, that is the temporal moment where we have seen this building of penal authority through public international law. Now, human rights has been doing very particular types of governance work, I think, at that time, because it's provided this moral justification for why this exercise of penal power is necessary and clear. And I think we really need to need to start to recognize who is focused on when we do that. And I suggest, and I think when you look across this, you see this focus on what could be termed kind of vulnerable or marginalized groups. Vulnerable, I say that because they get framed as vulnerable. And we look at it, it happens in notions of post-conflict states. It happens to marginalized groups such as migrants in relation to human trafficking, or it happens in relation to women. So we certainly see this with kind of the strong focus on sexual violence. And so we get this moral language for what is actually, if we start to look at transnational and international criminal law together, a much bigger regulatory project. So I think that that's sort of one of the kind of, if we think, kind of Felix to sort of touch on where I see the kind of apparatus and the connections between human rights and international criminal law. But then I think certainly with my own work previously, I think that empirical work can offer us a way to better understand the relationship between this apparatus, how this apparatus is being developed, and then where it gets applied in particular places by particular people. And here, the different spaces of, in particular, in my work, international criminal law, the different spaces then start to show us some of the negotiations that happen. And I think they start to show us the centrality of understanding how the people who are actually involved in the doing of this law make sense of what they're doing, because that influences the actual work that comes out. But this isn't something that is confined to international lawyers. So, I mean, Felix, as you and I know, in the many exchanges we've had, if we look at the Gacaca courts, the Nyangamagaya were ascribing very particular and very strongly normative meanings to the work that they were doing. And so we actually see, I think we need to start to look, well, certainly I argue that we need to start to open those dialogues between those spaces to understand the differences in these normative ascriptions that the people involved in this work are actually applying, and how they're making sense of what they do.
Fantastic. A lot of dialogues between different spaces and times maybe that we need to be doing. If I just link what you said with the opening kind of remarks by Siba. Now, talking about power, talking about rights and already issues of vulnerable groups, if you will, that already were brushed upon. Now, one of the core kind of issues arising from contemporary debates about the rights and the essence of human rights and whose rights, what rights, is around issues of race, and inequality and caste and many different articulations of inequality, including racism as well. Now, Lionel, you have been exploring this particular topic and in specific kind of spaces, of course. And we are in the era of, Black Lives Matter after, the death of George Floyd. Every other pundit basically said that we are in a revolutionary moment where, race rights or racism was gaining a new kind of breath and things were about or bound to change. So when we talk about human rights in relation to race, what are the core issues that should we be talking about, and in terms of both past but also present moment in time? Lionel.
Thank you very much. I'm very impressed by the beginning of the discussion, and yeah, I was supposed to talk about race, but I want to focus, and it is a bit related of the debate, to focus on a short piece that has keep me from writing my currently book on Morocco workers in France during the 70s in France, and also the racism that they faced at that time. But like many Africans, I'm deeply concerned about the situation taking shape in Mali. The last events related to the economic sanctions imposed on this country by ECOWAS, and the short informal conversation that I had with Siba convinced me that a legal reflection on the subject was necessary. The regarding ECOWAS law and jurisprudence of Malian Constitutional Court and of the geopolitical situation in Mali lead me to the following conclusion. And I think it is related to the subject, because you will see. First, ECOWAS imposed a political and legal agenda that is at odds with the current government and the expectations of large part of Malian people. Two, this agenda of the accompanying sanctions are in total contradiction with the ECOWAS treaty. And that is my reflection. Under these conditions, how can one talk about democracy, constitutional order, human rights, or respect of human rights? To put it simply, and this is my hypothesis in this piece, the illegality of ECOWAS sanctions is part of, a long colonial legal rationality in which law, violence, and command are intertwined. In order to get out this pitfall, we must return to, a political humanism on which Siba is currently working. So I have to state that as I'm not a great specialist of human rights. I'm practicing jurisprudence and economic law, and I'm focusing on race issue. But this is what the talk of Siba, Nikki, and Kerstin raising into my mind, and I like to talk, to thinking. In French, we say penser par cas, to thinking by empirical cases. And what happened in Mali today is a great lack of thinking African human rights subjects in the law, because we are still in the colonial legacy and rationality. So that is
quite challenging, and brings back, apparently tonight is a time to travel in the memory lane, but at least that brings back one of the very early remarks that I got as a young PhD, very excited to be writing on Africa-related topic on indigenousness in Africa. I met this prominent Ghanaian professor who asked me my topic, of course, as you always do in those conferences. And I was like, okay, I'm working on indigenousnness in Africa. I was like, who is indigenous? So like, okay, of course. There is this new report, I was nervous, there is this new report by the African Commission on Human and People's Rights, which enumerates a number of groups as indigenous. And who is not indigenous? That's, well, from what I'm reading is that we have the old meaning under colonization that everybody who stayed after decolonization was indigenous, but now there is this new UN-ish meaning of indigenousness, whereby these few groups are indigenous because of ABC conditions. So that's the definition of the African Commission. The professor asked, and I said, yes. But how African is the African Commission? That was the follow-up question. How African is the African Commission? So basically, if I take your proposal as well, the way you are explaining it, that the sanctions that are imposed by ECOWAS, which is a West African body, meaning, strictly speaking, African actors acting on an African situation in the global era of the narrative of African solution on African problems, you are still reading that as part of a continuation of coloniality. And if you allow me, why do you see that as not acting? I mean, after all, some of the advanced reasons around democracy, promotion of democracy, and so on, and in the era where you have quite very popular coups in West Africa. So why is that still part of that frame, if you may quite shortly elaborate?
Because they don't, they don't fit, and they don't address the local problem faced by Malian people. I don't go into detail of those sanctions, but the main sanctions are economic sanctions. So the borders of Mali are closed. Some goods some some necessary goods are transiting, but borders are closed. For a country like this, I think it is disproportionate. It raises a theoretical question about, can we talk about human rights or simply democracy or law or something like that, when it doesn't fit in a theoretical apparatus taking seriously the subjective of the people, the subjectivity of the people, because the rationality of colonial order was to shift the subjectivity of people, and to in France it was that to have just a thin layer of legality, but nothing else. So I think that when we think about this case, it's the ECOWAS, those sanctions are very rooted in this way of thinking. And now that there is a big, a big divergence between Malian people and ECOWAS. And it is not the end, because there were another coup in Burkina Faso, Guinea-Bissau since 3 years, since 3 days. So the coup are spreading all over the region, and there is a problem. And the problem, I think, is philosophical, is in the way we think human rights, democracy in Africa.
Fantastic. I have no doubt that we'll be touching upon a few of those, and probably that is part of the essence of my next question about human rights and governance, and both governance, local, but also global governance. I mean, if I look at the first kind of intervention I had from Siba, there was this idea of 3 different revolutions, 3 different kind of articulation of rights with different emphasis on which particular rights. But then different kind of realities in terms of those rights are deployed today. And quite a lot of growing literature, of course, is critical of that, but also especially again, the element of agency. Why do we have certain given specific norms, more emphasize certain given specific institutions, and certain given actors who, let's say, promote or who are at the forefront of certain given battles, with, of course, unequal ways of acting and means and all of the rest. Now, Siba, maybe it doesn't sound almost like a repetitive here, but what realities do we have then in terms of rights, especially in different spaces? Because when we talk about rights, also many lawyers will kind of debate that we have different rights in different places, we have different kind of accents in different places. But why do structures, why does power and global governance matter today in the articulation of, or how does it matter in the articulation of human rights today?
Yes. I think we should be, you made a comment and I want to go back to it before I answer your question. I think we should be careful. We should be careful to assume that if ECOWAS or African leaders were to decide something, then that is African. Mm. Right? Because even in the time of slavery, it was Africans selling Africans. So, right? But it was just Africans and what? Right? Africans have been, so there's independence. Right? Africans have been writing about dictatorship, tyranny, and etc., and our leaders not doing what we do, because in the French system, in the French sphere in particular, we have the Francophone neo-colonialism, etc., right? So to just say that Africans did it, therefore it's African, is actually a very dangerous proposition, because I don't take what France does to be what the French, who the French are, right? And that, so we have to be careful there. Because in philosophy, as in law, we make a distinction between political thought, political action, and political rationality. So the justification we provide actually may be up to debate. So the fact that ECOWAS does it doesn't mean that we accept the rationality, which is why people in Mali are protesting against ECOWAS, right? And I think that what Lionel is saying, and I'm hearing, is this idea that, and I think Nikki was saying that too, about global governance and geopolitics, that Africa is a space where certain experimentation are always done without regard to the consequences for larger population, because it suits geopolitical ends, right? So for instance, I'm sitting in the state of New York, where the governor says, anybody who says sanctions, boycott, diverse, whatever Israel, that's an egregious transgression, because you are it's anti-Semitic, because you want to punish all Jews for, first of all, it's not all Jews, it's actually Israelis. Even if Israel has a very substantial left, we know that. So it's not even all Israelis. We are talking about particular government, right? And settlers and etc. But right, you just go. But in Africa, there's sort of this general proclivity of just saying sanction, don't send staff, don't close the borders, and etc., for a bunch of thugs, if I may say so, who took over power. And those kind of states of exceptions permanent in Africa, where all normative supposition may be suspended because there's something profoundly in the midst in Africa that every means should be okay, is actually what people are reacting to in Mali and Burkina Faso and etc. Yeah. But with regard to I think it's a red herring to say that what we are talking about is that there are plural laws for plural spaces and etc. I actually don't think so. This is the thing I imagine it. I have never given up on the idea of universalism, by the way, and I'm actually anti-colonial too. There are two ways of coming toward universalism. One of them is going from the plural to the one, and that is that every particular articulation of human rights should be taken on its face, prima facie, to reflect on the human condition more broadly, because it affects humans and therefore may affect us too, right? And so if you look at what the Haitians were asking for, the right to shelter, the right to whatever, it applies to Haitians as well as to the homeless in New York who is sitting on a crater when it's cold. It applies today to every single displaced person on this planet who have basic fundamental rights, right? Unless you say that what Haiti says has nothing to do with the human, then you may dismiss it as peripheral. It's the same thing, of course, people are fighting in Africa today to have the right to free speech. Those are liberal, that come from liberalism, but it reflects on the modern condition as well as displacement and dispossession. So you can't discount one for the other. And if we take the idea that every single one of those reflect on the global human condition, of course, yes. So we go to the plural to see how they apply to humans in different contexts. So the Haitian Revolution has relevance in the same way that the American Revolution does, the same way the French Revolution, right? Okay. But we can also go from the one to the many. And this is where the traditions in the Black diaspora, the African descended diaspora, they have much more solid traditions, which is what I'm writing about now. And so I'm basically giving a preview of my book, right? The idea of no partial public sympathies. No partial public sympathies is one of the strongest in moral thought in the Afrikaner diaspora, is one of the longest standing from Quilombolas in 1609 until Nelson Mandela in South Africa, which is that we should, and Martin Luther King, the child, black child, white child, Nelson Mandela have fought against white domination or fight a black domination. The idea that we ourselves will never request something for us that do not apply to other people.
I see.
That is actually one of the most long-standing stuff in African traditions, which you don't see in any theory of justice in the West until today. And it's a different way of approaching the question of the universal. No partial public sympathies. What applies to me should apply to somebody else. And what somebody else claims should apply to me. Right? And I think that is actually, so we have different ways of thinking the universal. The universal in the West has always been that they have moral construct that are valued unto themselves and that everybody should just bow to them, right? Mm-hmm. This is the thing. The other thing actually has to do also with, and I want to comment slightly on Nikki's point about criminal, right? Criminal justice. When Europeans say that civil and political liberties are their traditions and not ours, that is actually bunk. Quilombolas in Palmares were the first to outlaw torture. When they outlawed torture in 1609, Francis Bacon, the father of modern Western science, was actually validating torture as a way of obtaining evidence. Go to Francis Bacon. The slave was the first to whom it could have occurred inherently that torture was a bad thing. So in the Afrikaner diaspora, Quilombolas are the first to outlaw torture. Ida B. Wells in America, Black woman, was the first to rally against police power given to society. And in the French Empire, the law that outlawed forced labor was called La Loi Houphouët-Boigny. We have longer tradition in civil and political right than anybody else, any moral and political entity in the modern world. So when some idiot in Africa tells me because they are in power, this political rights thing is a white people thing. No. We oppose torture. We oppose excessive police power, fugitive slave laws and etc. We oppose forced labor. Between the slave owner and the slave, it doesn't require any mental gymnastics to understand that it will have occurred to the slave, to the colonized first, that what was occurring to them should not happen to any human being. Those are actually our traditions. So I don't know where you get the idea that the only question is when we say universal, what kind of moral thought are applicable to other people, and whether Europeans are exempt or the West is exempt from universal jurisdiction, right? They can extend a universal jurisdiction onto us, but God forbid you should talk about Obama or George Bush or whatever. Mm-hmm. Otherwise, it's not that the ideas themselves are not universal, that we don't understand universalism. It is that universalism is deliberately suspended. It is also that the manner in which we approach universalism is at its core inadequate. But we have much longer tradition of universalism, of think of the human as one. I stop there. Thanks.
Fantastic, very provocative. By the way, I'm bringing up some of the kind of narratives and the provocations, of course, which I don't necessarily share. And yeah, go ahead. Absolutely, I guess that's my role here. Yeah. And maybe Sheshti, picking up from what Siba just said about no partial kind of public sympathies. I mean, many kind of arguments I read in the deployment of human rights language, if you will, or rhetoric, as we were rightly told by Siba, is that, of course, there are certain given specific sets of values, especially indeed, as he rightly pointed out, mostly civil and political, certain given liberties that liberal societies do share. And there are certain given other practices or moral kind of, let's say, norms that liberal societies don't. And therefore, all values are not equal, if you will. And if you read, let's say, the likes of, Wilkie Mlikas, or as opposed to, let's say, precisely when Siba was talking, I was picturing the book by Chandran Kokatas about the liberal archipelago, where more or less all values are treated as equal. And then when they come together, that's where you start ordering a liberal society. But most liberal societies tend to say that we have these norms, but also there are others that we cannot accept as liberal societies. Then how do we operate? What kind of governance? What are the justifications for certain given human rights, or for even a certain given ranking of human rights when they are deployed? And of course, touching upon how they are deployed, as Siba just last mentioned. Quite a lot too.
This is a broad question, and something I don't know if I'll be able to respond to in a neatly and structured fashion. But I think, but I'll give it a go. And I appreciate also what other people have said now. This is really stimulating and a lot of food for thought. And Siba, I agree that, I don't know, universalism as a research object in itself is kind of what I was intrigued by, and trying to sort of figure out what work it does as a politics. But it also, I also wanted to connect in responding, Felix, to what Nikki was talking about too, in terms of this sort of global governance and the work that human rights and penal power does in this really construction of a global moral order, or attempt at a construction of a global moral order. And for students, I think it's useful to, revisit Emily Durkheim here, actually, and to think about how, I mean, to not take him on face value all the time. I mean, you have to account for power in his work, which he doesn't always do, but to think about the work that penal power and human rights and these technologies, really, these global technologies does, what work they do as an attempt to reintegrate a common moral community, which obviously doesn't maybe exist, but that it is a politics there that tries to create a global moral order, and that should perhaps be often more articulated than it is, because it's not always do-gooders and sort of what Nikki was talking about as sort of providing the moral justification in human rights and humanitarianism and also development is what we've also seen in international criminal justice, that it expands these sort of technologies of international criminal justice and these regimes of global governance. They expand through legitimacy discourses such as humanitarianism, development, and human rights, I think. Also because these are technologies that needs other forms of legitimacy work when they're disembedded from the nation state legitimacy. Within the nation state, criminal law is legitimated just by virtue of being within the nation state. But as soon as it sort of transgresses the national, how do you justify punishing other citizens? How do you justify punishing the states of other states? Well, you do that through alternative legitimacy discourses such as development and humanitarianism and human rights. But Felix, also in terms of these sort of so also within this construction project, there's also processes of othering going on, right? And this is also connecting back to Durkheim. This is the work of criminal law. And there's this really fascinating article by Anne Sagan in Millennium, where she does sort of use, or Durkheim is very much present in her interpretation of international criminal justice and the sort of neo-colonial project that it is, and how it sort of uses African subjectivities in these processes of othering to construct sort of the difference between civilization, this global moral community, and barbarism. And how sort of these subjectivities, both as victims and perpetrators, the African perpetrators and the African victims, does a lot of legitimacy work for construction, or for constructing this sort of delineation between civilization and barbarity. Yes, so yeah, I think I'll leave it at that. But also say one more thing, and that is, you know, connecting back to partial sympathies and the politics that human rights also are. I mean, and you talked about being in New York now. I mean, human rights have been, you know, the US have been at the forefront of exporting human rights as a foreign policy tool, but they don't speak much about it internally, right, to the domestic citizens. That is domestic rights. So when I did I did some research on Guantanamo at the military base there, right? And then human rights are sort of a no lingo. That is seen as particular interest. The human rights NGOs that observe the military trials there, they are not at all accepted as sort of having moral authority in universals or in sort of the international or whatever. No, they are seen as representing particular interest. And the universal is more sort of the military commission because they represent the people, because they've been authorized by Congress. So there's a very sort of different dynamics, obviously, when we speak about human rights within state power or human rights within the international, and how it sort of transverses the national and international. Yeah.
Fantastic. Now, I'll come back shortly to a question that I see already in the chat room from Nikki to Siba. But just back to Nikki now. I recently was reading Abdullahi Ahmed Anaim recent book on decolonization of human rights, decolonizing human rights. And what I found fascinating was quite a clear statement from him that international law and intergovernmental institutions are incapable of preempting or providing effective remedies for human rights violations to meet the legitimate expectations of self-determining human beings in their communities around the world. And he went on to explain that when he talks about decolonizing human rights, basically he's reading the irony of the continued civilizing mission of colonial powers under the guise of protecting human rights. Now, I was also recently reading something around, social media and hate speech, and one of the quite interesting scholars, and one of the chapters was around the UK, where you are based, and the imbalances about who is protected and who is not, what values are protected and what is hate speech, who is generating hate speech against whom specifically, and this continued certain marginalization and casteization, if you will, of certain given demographics. Now, looking back at that statement around decolonization of human rights, but also this issue of marginality, both in human rights, but also in criminal law, what are your views on that, before I go back to your question?
Great, thanks, Felix. I think this is all a lot to reflect on. And I think so maybe I can talk about what my response will connect to Siba's comments as well, because I think that I thought it was very powerful to think about the ideas of this sort of longer history of the way through which people have understood what currently gets termed human rights violations or grave breaches of international law, and that these are particular ways of describing conduct that has been considered wrong as a universal. So the reason why one could do this level, at least in part, the reason why one could do this level of institutional building at the international level was because of the strong plural recognitions of the wrong. And I think one of the things that then, which I think is an important point of entry and reflection. But I think one of the things that seems to have resulted from that, certainly in terms of international humanitarian law, and then how particular types of particular breaches of international humanitarian law have then given rise to individual criminal responsibility, has suddenly meant that we've had this enormous narrowing of the sets of possible responses to these violations. And in doing so, I think we also narrow our understanding of the causes of those violations. So suddenly it's particular individuals who are only particular individuals who are responsible, rather than economic policies, rather than longer-term histories of exclusion, rather than particular economic pressures or particular economic extractions and environmental pressures that have benefited powerful individuals and powerful states. So we suddenly simplify what we understand to be the causes of that violence. And I wonder if we broaden our sets of thinking about the responses, can we also broaden our understanding of the causes of those violations? And I came to writing on Rwanda through my experience in South Africa, through the South African Truth and Reconciliation Commission, and at that time there was this very lively debate in transitional justice around different sets of possible responses to large-scale violence. But what I think we've seen in the 16 years that I have been writing on this and thinking about it is that we've seen this sort of narrowing towards criminal law plus. You could have criminal law plus anything. Criminal law plus land reform, criminal law plus artistic responses to violation. But for some reason we have completely set that criminal law must be included in that. And I just wonder if it's the ways through which it might be productive to open up a wider set of questions about responses to these violations that are universally recognized as wrong.
I see. Fantastic. Maybe before I go back to the conversation you initiated here with Siba, who is already partially responding, but I will come back to that. Lionel, allow me to take a step back. Maybe indeed, already you started by problematizing the response of ECOWAS to the particular situation in Mali, based on this legalistic application of the Charter and so on. But Nikki here is again triggering us to look back at rights, at the situations, at the conditions that inform certain given dynamics. So in talking about rights and so on. So, of course, outside readers and looking at the phenomenon, of course, in the West Africa, a few Western African countries, many would probably just generalize in Africa, and then think about why is that happening now in the era of, the African Renaissance and so on. But most importantly, then back to your point, what should be the appropriate responses to such kind of phenomena? So what is your take on that, still within this kind of framework of human rights that we are talking about?
Thank you. I can't remember the moral principle stated by Siba. I can't remember. I can't say, but in my mind it means radical equality, and I think this
no partial public sympathies, if I correctly quote him. Sorry.
No partial equal.
Public. Sorry.
No partial public sympathies. No partial public sympathy. It means that when it comes to law and morality, we should not make exceptions on the basis of our own private sympathies.
No
So private
partial,
sympathies are private, public sympathies should be equal.
no partial public sympathy is what is precisely be breached in Mali. Why I'm saying this? You know, the current sources of discord between ECOWAS and Mali, namely a case law of constitutional court in Mali. What is it about? You know, in May 2021, on the letter of resignation of the president of the transition and the decree terminating the functions of the prime minister and member of government were referred to the court by the minister director of cabinet of the vice president of the transition. So to put it simply, the Constitutional Court of Mali validate the switch, or what we call it in French, the vacances du pouvoir. So the fact that the
Power vacuum.
Thank you. The fact that Assimi Goïta must be now the president of the transition. And when you read the judgment of this cause, of this constitutional court, this judgment has its own rationality. But I think that ECOWAS didn't even care about this judgment. I don't want to get into detail, but you know, the judgment say that in the transition charter, it is possible to replace it is possible that vice president will replace the president of transition. It is in the text. And the court apply what it was in this charter, but it was not in the interest of ECOWAS. And I think the problem starting there. So trying to terrorize this, you know, there is a big problem to taking seriously the law and also the constitutional law, the domestic law in our country. Because when you see all the communication, all the communique of ECOWAS, they never mention the jurisprudence, the legal decision of Constitutional Court of Mali. But there is a rationality in this legal system. But you know, they pass through. They don't care. And it leads me to this principle that mentioned Siba. And just to say that we need in Africa more philosophical, political philosophy, political philosophy thinking of what is legal subject, what is our, we must rediscover our own humanism. And I think this is the point, not to make another reform of good governance, etc. It's not a problem. The problem is much deeper than that.
If I may just jump in there, since you said, Felix, earlier that we can make
Please,
sort of addition. Yeah, because what Lionel is actually saying is very important. Because and you can see the debate you can see today emerging in Mali, Guinea, Burkina, and etc. is whether agency, to use the language of agency, about African agency, whether Africans have the right to self-govern, and whether certain interferences so disable African agency as to they themselves begin to be violation of law. Outside of military coups and etc. Is there a fundamental philosophical principle about self-government to which Africans are entitled as a question of both law and morality?
Fascinating. This connects, and I'm back to you, Siba. This connects, and I'm gonna kind of, again, as I'm doing, bring a few different things together, and you pick and the way you approach this. So first, there is this. I mean, Nikki's point here was that the longer histories of recognition of human rights violation is so interesting. And what about the plurality also of possible mechanisms that are deployed in response to those violations, to those wrongs? What is your take on that? And maybe I will link that also, talking about histories, to the development of codification of human rights with Europe post, at least recent history of post World War II, with Europe deploying human rights at the time. Also, many powers were still colonizing certain given territories. Linking that to the point of Siba, rather of Lionel, there is also this idea, at least prevalent in African youth, at least I talked to, that many countries, including like bodies like ECOWAS, which partly depend on certain given funding from European Union kind of institutions, act the way they act, not really as part of expression of an African agency, but just to please, again, the funding masters and so on. So plurality of mechanisms, but also, again, the articulation of agency for what particular reasons. Back to you.
Yes. Actually, again, since I'm not in a courtroom or in a classroom, I'm just going to, and I'm not even in the question. I actually think there's a question that emerged in Africa, in Francophone Africa, after World War II. And I'm saying that now in reference to somebody who made a comment in the chat about French violation, right? The French committed mass murders in Sétif and Guelma in Algeria on May 8th, European Victory Day, was the day the French chose to commit those slaughters. Which means that the signal that was that whatever FDR and the British guy, Portuguese guy, Churchill may have decided, though Churchill himself dropped bombs in Greece and etc., we know that. But whatever hell they may have said in the Atlantic Charter, France was basically saying it doesn't apply to us. Right? And if you add to that charroing, right? And if you add to that the fact that the French on the day of liberation in August 1944, de Gaulle issued a decree saying, il faut blanchir l'armée. He wanted all the blacks to be sent to the barracks so that history does not record that black people freed Paris. It's a decree, it's a real. This is not conspiracy theory. Blanchir l'armée for that celebration. Yes, right? So yeah, the question there about whether our skepticism doesn't have to do with what Europeans were doing after World War II, the crimes of colonialism, and etc. I actually think that, well, that's one response. One response is skepticism. The other response actually might be to confront something Nikki was saying, and Christy also said at some point, which is that whether it's in our interest as formerly colonized people to insist on law as a language for us as universal community, global communities, while we are disputing the language of law under which we live. So we are not disputing law as a language, we are disputing the particular laws that we have today that govern us. And the decolonial project, as I understand it, where I'm sitting, is to dispute the foundation of the language of law today and the practices attendant to them. Because they mean nothing except raw power, exercise of raw power. But we cannot surrender, and in our traditions, we have the decolonial project never surrendered the language of law. And what that law should be is what the fight is about. And that fight, the person who understood it in 1948, when they were establishing the Universal Declaration of Human Rights, was Eleanor Roosevelt. When everybody was talking, it should be people's rights, human rights, and etc., everybody here and our listeners should go back and read the preface in English, in the English language, the original. Eleanor Roosevelt came to the room and said, you know, forget all that stuff. Why don't you just say everyone? They can call themselves people, individuals, and etc., which is why the preface in the Universal Declaration of Human Rights says everyone. It didn't say individual, it didn't say people. It actually wanted to skirt all of those to just say everyone. Call yourself whatever you want, but we are here to try to see whether we can conceive of mechanisms to govern ourselves. And so my decolonial project is not to surrender the language of law, the language that people should be held to account, people, whether they're in my country or outside. It is that the current language, the current language of the law and the practices attendant to them are completely egregious and still colonizing at some level. I stop there.
Fascinating, fascinating. And how are they still colonizing today, especially when dealing with some of the current issues we are dealing with? I mean, I promise, at least in the exchanges, that some of the things really which are very kind of topical today is things around COVID and the different kind of problems of human rights that arise from that kind of very peculiar situation, of course, where many kind of sections of populations in different parts of the world are still even more fragilized, if you will, by the pandemic, and their basic rights, including indeed what you are insisting on, not only civil, political, but most importantly, economic and social rights, are more fragilized. What are the issues today in terms of human rights? Are there new issues that are rising from COVID that are not there already in terms of addressing, let's say, the power structures and imbalances within the human rights framework, both in terms of norms and institutions?
Is that to me? Can I say 2 minutes? Yes.
2 minutes and then everyone else.
Just 2 minutes quickly. The thing is that what COVID has shown is how far we have gone to giving corporations and capital privileges, immunities, without insisting that those immunities be weighed by certain obligations, and we give them privileges that the state enforces against everybody who may be victims of capitalism. So that even the Doha formula, when we had AIDS, is no longer available to us today, right? That in international, talking about mechanism, in international law, you see that's when UNCTAD dies and is replaced by WTO, UNCTAD 1974, WTO 1995, whatever, that's what happened. Basically, the state has surrendered certain functions of governance to capital, which has no respect to the kind of moral foundation of human rights discourses with which we began, which is that humans are not just biological entities, they are all moral and extra and spiritual and all the rest. I stop there.
Fascinating. Anyone else still on the COVID issue? This time I have been following a linear kind of stuff. Please feel free now to be even more kind of, yes, Chesty, please. Spontaneous.
Yeah, no, I just gave it some thought. And I think one of the things that struck me initially when this happens was also, I mean, I think it in many respects epitomizes global inequality still. But I also think it really was a test case for globalization. And besides capitalism, as you talked about, it also, you know, this pandemic epitomizes world risk society, as Ulrich Beck talked about in terms of global threats, right? It penetrates border. It doesn't matter what borders does. These threats, they come. The virus came, right? But the response was not global solidarist, and we saw really a withdrawal, a retreat to nationalist policies and borders again. And I think maybe Nikki, you researching borders might have given this much more thought than I have, but I remember I was really struck by it also within the EU, you know, which praises itself on the free flows of goods and capital and whatnot. All of a sudden borders, you know, rose up despite of this epitomizing global threat, and instead of a global response, it was nationalist response and withdrawal. And I think that is something to think about in times of crisis, that that one withdraws to the political, I think.
Fascinating. I don't know, Nikki, whether you want to particularly kind of especially also add something on this, or rather if you can actually really more elaborate on your research on border issues and also implications for human rights, because it's very fascinating probably for our audience.
Thank you. Wow, there's so much that I want to talk about. It's more about how to restrain myself. So I think the first, just to build on Siba's point in relation to the language of law, I just think that's incredibly powerful. And I think then it opens up, for me, it opens up a whole lot of questions around in international criminal law, around the returning an emphasis onto crimes of apartheid, returning an emphasis onto thinking about how colonial wrongs constitute international crimes, and trying to stretch some of those temporal boundaries. So that's one of like reclaiming or trying to pursue progressive agendas within the current language. And I apologize for restricting it to a discussion of criminal law, but reclaiming the language around particular crimes, or if you're trying to, or what other forms, and I asked this more openly, what other forms of language of law, what would it look like? So I would really just value Siba's reflections on that, of what would this a reconstituted decolonial language of law look like. On the question of COVID and borders, actually, and maybe this goes to that language of law, because if I stay with my research on borders and I've been interested in some of the contradictions and possibilities around the emancipatory potential of international criminal law in relation to borders. So the work of Itamar Mann and others who have pushed for the recognition of European border control as a crime against humanity, and the ways through which that has happened, and the level of reluctance by both the International Criminal Court and most recently the European Court of Human Rights to start to take those claims seriously. But then, so there's that, the possibility of some of the more equal application, if we go back to some of the less partial public sympathies, so to push for that, to push for more radical equality through those legal mechanisms. But equally, we then see in the work that I've done, we then see charges of involvement in international crimes being invoked as a way to reinforce borders. And I've contributed to a special issue that Kirsty edited along with colleagues on how I saw this as emerging in ethnographic related work, where suddenly individuals are being charged for an immigration offense that's based on an allegation of involvement in an international crime. And so we start to see some of these contradictions around the work that criminal law is doing. And so taking that finally to the COVID context, I think we have seen the kind of resurgence of national borders, and I think that's something that we should all actively be trying to think past. And I think we've seen this acceleration of inequality. But when I was reflecting on the question, I actually came to, one of the hopeful aspect, one of the possibilities of it could be a closer reflection of our relationship with social ecological systems. So how do we start to think about human as connected to natural systems? And then I think if we start to look at complexity theory and Paul Cillier's work, he's a South African theorist who looks at complexity work, he kind of prompts us to think about complex social systems and complex ecological systems as deeply informed by memory, by past patterns of action. And so here, this I think asks us for those of us working in responses to large-scale violence, to recognize that the memories of that large-scale violence are always going to be informing the current sets of responses. And so I think this is why longer histories of pre-colonial, colonial, and colonial violence in particular must inform the discussions of any type of responses to current episodes of violence.
Fascinating. Now, allow me to step again slightly out again of the COVID context, and still as we reflect about the human at the center of human rights, allow me to add the complication of the collective in the human, and I would love to hear more Siba's reflection first on this, and then maybe Lionel precisely, because let me elaborate on what I have in mind. Now, already in the early codification of human rights in the last century, 40s, and then Africa in the 70s, 80s, there was this debate about the preeminence of, as rightly Siba mapped, which rights under which have more preeminence, civil and political, economic, social, cultural, and so on. But most important, group rights as well came up very strongly as something that actually many liberal democracies did at the time quite object to, as something that should be meaningful or even articulated into rights. That was in those times, and we know the histories of codification then. But and the sources of codification of group rights, if you will, or collective rights. But then in the indigenous rights, as I said, minority rights ended up developing, and few countries did, including liberal democracies, actually became champions of collective rights as well, especially when it becomes certain given marginal groups. Shares to you are in the northern dirty countries where Sami rights, for example, are very important as collectives with specific group differentiated rights. But at the same time, there are still quite strong objectors to that kind of very idea of the possibility of collective rights. And Lionel, you are in France, which has consistently been one of those countries, but still very much view with suspicion this very idea of collective rights. I think in France, still communautarism is still a bad word, and so on. A community is still not necessarily something good unless it's a specific community. Now, to me, this question is quite important. My work has been around this area because whether we are talking about human rights law in theory and practice, but also international criminal law in theory and practice, we tend to focus always on individual as agents, perpetrator, victims, and so on. But sometimes we forget the community and the expression of community values and so on, and how they impact both the idea of human rights enjoyment or the idea of justice. I have so many kind of headlines about Lubanga being, convicted, and this is the day for all Congolese and so on. And are you sure? Are you sure that that is a good day for that's a member of his community and so on? So where does the community fit in this whole debate, both in the past and the present, but also going forward? Back to you. All start with Siba, maybe. And back then, Lionel.
Yeah, I think it's a false opposition to say that you have individual right here, we have communal right there. Mm-hmm. That for me has always been suspicious. When I was talking about the human, I talked about human capacities and faculties, right? The faculties, we have sentiment, we have cognitive faculties, we have, you know, sensual, sensorial, blah, 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 all of those, right? But we also live as humans in particular capacities, as citizens, as lovers, sometimes as criminals, as whatever, right? It is one of the things that human faculties draw them to is attachment. And I think that people should be free to belong to communities to which they want to belong. Once they belong to those communities, if self-government, for instance, is a right that we give to communities, of course they should be entitled to them, right? Mm-hmm. So I actually think that is in the French context as well as in America and even Australia today, that's sort of a false problem, right? But there's a danger to the solution that the French want. And I'm going to go to Turkey to make the point. The Ottomans had their willet systems and etc. Everybody says it functioned maybe this way, that way, that way. All the violence, especially the Armenian genocide, you know when it happened? It happened after the Tanzimat, when Turkey decided to go for Westernization. The nation state, the passage from Ottoman Empire to a Turkish state, is what led to the Armenian genocide, right? You go to Japan, you see the same thing, right? So, in fact, the kind of collective entities that people may favor in the West, right? Germany was a modern state, right? And so I actually think that this is the case again when we should not go ahead of ourselves. I think that it's just best to say that humans live in certain capacities and that we have the right to the kind of attachment and affinities that we want to, and that those should be respected and institutionalized in some fashion. But it's not opposing community to individual, because if you go to community in Africa, for instance, where customary law was codified and made hard, right, to sort of to serve colonial interests and etc., and after colonialism to serve the interests of people who are not known to respect their own people's rights, then we have a problem, right? I stop there.
Good. Fantastic. Lionel, so there was some kind of provocation about France and communautarism and all of the rest. Which rights are we talking about?
If we talk about France, it would lead us to another debate. But I think that in France and also in United States and in the West, and broadly speaking, I think this is my point of view. We are now in the moment that the so-called lightning area, les lumières, we are facing the own limitations of our so-called liberalism and political thinking. What it is called today communautarism, taking roots in, you know, the assimilation and the mixed between human, like French Revolution, think about it, and white men. And this confusion are still alive today, and take the word communautarism, etc., etc. For us in the South, I think, in particular in Africa, I think that there is a urgent task to rethink African human rights charter and to broaden our comprehension of it, not only to the decolonization area, but to broaden it and to include mass crime in Sierra Leone and also in Rwanda. And also, we must include all this genealogy that Siba is talking about from Haitian Revolution to Quilombolas, etc., etc. This is, I think, the right time to do so. And in doing so, I think we will be able to begin governing ourselves.
Fantastic. Now, we have now around 14 or so minutes before the end of this session. And in the same kind of thread of question, let me turn to Chelsea. I contrasted France, for example, I'm being kind of with two concrete examples, with the Nordic countries like Sweden and Norway, of course, and which have kind of group differentiated rights, especially with dealing with the Sami kind of rights, especially in the upper north. But that one reality, but at the same time, Nordic countries are also very strong globally in pushing for human rights. I mean, Sweden and Norway are all over the place with especially gender rights in the global south, especially, which kind, of course, does something around, dealing with certain given specific issues certain given communities have, but at the same time, tend also to emphasize certain given norms and operates in certain given ways that reinforce certain given structures. So what are your thoughts on those practices, but also going forward, I guess, and we should be also reflecting all together, what is the future of human rights, both in theory and practice?
Yeah, this touches upon a new project of mine, actually, where I look at how the Scandinavians export penal power, because they export a lot of things. As you said, they are sort of self-articulated do-gooders and global cemeterians and humanitarian superpowers and whatnot. So in this new project, I look upon this through the lens of branding in a way, and how they brand themselves as being good punishers in the dual sense of the word, both by sort of doing, by being good at punishing. We pride ourselves on not punishing too harshly, but just appropriate or just enough. And also punishing in the name of the good. So this is penal power that travels beyond the Scandinavian countries and into the global south, primarily through these discourses that I talked about previously, humanitarian discourses and development aid. So sort of a penal aid to build up societies elsewhere. And there's these frictions here that I find very fascinating and quite scary at times. But I wanted to connect a little bit to what you talked about with agency and law, and what Siba also talked about, and like the nature of law, right? Because the Nordics have the welfare system has a very intimate connection to law, and our societies are built very much with legal reforms all the time. But law in connection to what we're talking about today, I mean, law has this. It's important to have a temporal perspective on law. I think it looks backwards, it adjudicates, but it's also constitutive. It creates narratives, it creates histories, it creates societies in which it is part, and it creates truths, right? And it's important to be aware of that and to be critical towards it, I think. And what you talked about before in terms of agency and the structural, I really agree with Nikki here, because law is also reductionistic, or it has this reductive capability, especially adjudication. It operates through these binary codes, right? Victim or perpetrator, guilty or innocent, and it creates, and that frame of tackling a complex problem has grand consequences, right? If you say that this group is guilty and this group is innocent, then that bears tremendous consequences for the historical narrative or in the history writing of that setting. But it also has this emancipatory potential, as we talked about previously, especially through strategic litigation and stuff like that, right? So we can't reduce it altogether, but I think it's important to often be aware of what are we talking about when we're talking about law. Is it its backward logic? Is it its forward logic? Is it its adjudicative characteristics? Or is it sort of law as a normative institution and code and set of morals, really? So a bit all over the place there to end, but I just kept thinking about this when I heard Siba and Lionel and Nikki talk now.
So you touch upon, of course, the emancipatory kind of power of law, of course, as a question, something that was tabled by Nikki in our exchanges. What is the future? What future of, I mean, looking backward, looking at current reality of all of this we have been debating, what future of law, but also in your case, you have been mostly focused on criminal law, including international criminal law. What future do you see in this sense?
Me, the future of law?
Yeah, you can start and then Nikki, yeah.
No, I think in terms of international criminal justice, I do see and human rights law and international law as multilateral organizations and global governance. It has a bit of a legitimacy problem, and it has had that for quite a while. And Siba talked a little bit about or touched upon, the issue of representation previously, and I think this is still something that needs to be tackled with. How can law integrate representation both as representing a politics of ideas, but also a politics of bodies, right? How can law, as it is implemented, be something that resonates with people? And to do that on a global scale, I think is tremendously difficult, if I can be as frank.
Fantastic. Nikki, the same.
Thanks, Felix. I think what I'm going to say, it's perhaps limited, but I think as far as my reflections have gone, we need to be thinking more extensively about what legal humility might mean, and start to recognize some of the limitations on the capacity of law. And also I think then so in the transitional justice context, Kieran McAvoy sort of argued for legal humility in sort of 2007, and was particularly in relation to international criminal justice. But I think that this idea of legal humility, we might be able to go further, because we might be able to recognize that it demands a particular reflexivity from anyone who's making claims to exercising the power of law, and that we might be able to, I think part of what needs to be pushed for is that that we abandon this claim of neutrality and start to really take seriously what it might mean to exercise restraint. And in that exercise of restraint, how we might be able to engage less in the kind of less in the power and oppressive possibilities of law, and more in thinking very carefully about what it should be constrained by. So I'll stop there.
Fantastic. I will reserve the last word for Siba. Lionel, any final thoughts on this, or any other things that we have discussed?
No, fine. I will be humble myself, like Nikki. So no final thought. No.
Fantastic. As people are still kind of paying attention to the final word of SIBA, using again the droit d'aînesse that I used at the beginning. Let me just remind you something I forgot to say at the beginning, otherwise Sarah will give me a punishment. So I was instructed to remind you that, of course, this Salon is connected also to a summer course that we are organizing in Rwanda. There were registration, of course, for students who would be participating, but for now, the registration is closed due also to the current COVID and uncertainty about COVID regulations and the evolution of the pandemic. But there is a possibility in the future also of possibly opening the window. So that was very important that I mentioned that. I know for sure that you have seen all the material about the summer course as well in your correspondence. And for those listening to us, of course, who have questions, they should feel free to contact any of the people here organizing. So with that in mind, and the last question, but also whatever else we discussed, keeping the human in mind in the framing of human rights, and especially in articulating them within deploying them in different kind of spaces, but also thinking about still the humanity at the center. Siba, what are your final words of wisdom as we go towards the end?
Well, actually, I thank you very much, and I really want to thank everybody on this panel. I've learned quite a bit. I just wanted to conclude on something, and it connects actually to what Nikki and Kirsty said, and it has to do with humility and etc. Whenever I hear humility, legal humility or humility, whatever, and I think I really hope the West hears that. Adlai Stevenson once said at the United Nations that we are all in need of aid, and the West certainly need a hearing aid. And I hope they hear that, and I hope they exercise a little bit of humility. But for us in the African diaspora, it's not a question of, has never been a question of humility, actually. It has to do with some certain degree of abnegation. Abnegation. Quilombolas were the first people to admit that all religions were equal, all humans were equal, all ethnic and religious groups were equal. It was the first entity in the modern era that had free and equal citizenship for all. Haiti, when they became, after the Haitian Revolution, they said we are all Haitians. Nelson Mandela said, I have fought against white domination, I'll fight against black domination. And I think that the idea of just recognizing that other human beings are equal is a good starting point. And it's really a good, and maybe that's what Nikki meant by humility, that we just admit that we are all equal and equally flawed, equally whatever, and all that stuff, that our appetites stand sometimes in our way and all the rest, right? But I actually want to come to something else. This idea that Africans want to exercise the right to self-determination and etc., which has come into question in Mali and elsewhere. And we sometimes, that is sometimes viewed unfavorably in light of what is happening in Europe. I just want to suggest that the European project, before this turned to the right, at some point, the left in Europe understood that we actually really, the European project itself, as a Republican project, the citizenship project, right, that it was in trouble. You know, in the night, when the whole started going into whatever, would starting to go to the right and to this sort of uncharacteristic non-Republican direction, the people who tried to save the Republic in Europe and the commons in Europe were all from the colonies, and they are all women. Gina Miller in Britain, in the context of Brexit, Christiane Taubira in France, in the case of sort of national citizenship laws, Cécile Kyenge, Congolese woman in Italy, and Francisca Van Dunen in Portugal. That was actually a very, very interesting moment to understand how Europe actually gave up on the Republican ideal. And I think that along with the return of sort of imperial policies is one of the most troubling manifestation of our moment today, or of the moment in which we live, right? And in that context, we should actually, and I want to say that because Black women in Europe are demanding equal citizenship, we should not give that up in Africa. And so, yes, we should all be mindful of empire, universalism, imperialism disguised as universalism, but we should not give up on the idea of the law, even if the language of the law is troubling to us. I'll stop there. Thank you.
Fantastic. Not giving up on law, probably reflecting more on how to make it more equitable, if you will, in different kind of, again, situations. Now, precisely 8 o'clock where I am, of course, 2 in the States, Canada. I have no other thing to add except thanking you all really for a very engaging, basically for me, learning kind of curve here, listening to you all, reflecting on these very quite complex issues of the meaning of human rights today within the background, against the background of the different kind of crisis that we are facing beyond the pandemic, which is the great one. Thank you very much for having talked to each other. And I understand that for some, it was the first time to meet, but I loved the way we went very fast, literally on a first name basis, depending again on some kind of academic culture that may be impolite. I apologize for having done that. I'm from flat Netherlands. We do that, we commit that crime all the time. So thank you for allowing the flow of the conversation, for really making this very interesting for at least for me, definitely. I hope it was as well for you. I hope it was for our audience. I'm very much looking forward for further engagement on these topics in your respective reading your work, which I encourage, by the way, anyone listening to do. These are very, as I said on my tweet, these are very prominent researchers who have produced a kind of wonderful body of work on the issues we have been discussing. But also I look forward to your participation in the Rwanda event, which I pray to whichever God to make it happen under this pandemic. Thank you.
But Sarah said that there will be a slight delay, so please wait for, yeah.
Yeah, of course, wait for the message. Okay, it was because it was, there will be a slight delay, okay. Oh yeah, that was in view of the comment she made earlier of knowing whether we are online or offline. But
offline,
feel
okay.
free to interject and to continue, absolutely. We are not switching off, so I'm not, but feel free to know that we are still online